There's a huge case going on in California that could make student athletes employees, and nobody's talking about it. Let's get into it.
Realignment, expansion, and rule changes are always in the news, so we're back on the big mountain to keep you updated.
It's great to have you here on the mountain. I am JY. This is my good friend Steve. And Steve, we want to talk about something that is not getting a lot of reporting right now. I'm really surprised that we're not hearing more about this. This is a case in the labor courts in California, and it's the National Labor Relations Board. I'm going to be calling them the NLRB as we go through this for short. But the National Labor Relations Board versus USC, but really USC, the PAC-12, and the NCAA. It's the trifecta of defendants, so to speak. They've had two hearings now. Their first hearing was back in mid-December. They just had a second hearing here last week. I want to talk about both and some of the testimony that came out of it, at least what we were able to find in terms of reporting on this. As I said, there's not been a lot of reporting on this, and this could be massive in terms of where things are headed with student athletes and conferences, NCAA, and all that jazz. We just dropped an episode regarding the NCAA and where they might be in 2030. I'll make sure I put that link at the end of this episode, in the end credits or whatnot, end screen, so you can click on that if you're interested. It's a deep dive, like a 55-minute sucker, but really, really good stuff. But let's dive into the hearings here. I'm going to start with the first round of hearings, which was witness testimony back on December 18th. 2023. This is when things kind of got started. The NLRB is arguing that student athletes should be considered employees legally. They're trying to show that the university, USC, the PAC-12, and the NCAA are joint employers of a student athlete, a player. To do this, they're focused on player schedules and playing conditions. The NLRB opening statements included that the three entities, USC, the NCAA, and the PAC-12, abused the term student athlete to deprive them of federal rights as workers. They argue that the three entities have instituted and are upholding rules that violate federal labor law. Massive charges here, again, if this goes through. The three deny, USC, NCAA, PAC-12, deny any wrongdoing. They argue that the NLRB is trying to make policy changes, and that should be left up to Congress. Something I think we're going to hear a lot of from the NCAA in terms of their defense to some of these things. It should be left up to Congress. Very important here is that there's been some newly relaxed doctrine by the NLRB that broadens the idea of this multiple companies qualifying as joint employers and sharing in any liability for labor law violations. This occurred with a Democratic NLRB that rescinded some Trump-era rules. Not getting into politics, just explaining why we are potentially where we are here, kind of opened the door here more recently and allowing this, at least this joint employer type of issue between the three parties. In terms of testifying, two players testified, former USC players, testified that USC retained a rigid control over their lives for almost the entire year round. They detailed the perks of being on the team as free meals, free gear, free university apparel, and gifts for making it into the playoffs. They stated that they spend 40 to 60 hours a week on football activities. These two players are football players, obviously. Team staff would track attendance of players by scanning their fingerprints. Cross-examination discussed that this monitoring was to ensure the athletes maintained their health and academic progress, and that enrollment in the university was never in jeopardy, and that participation on the team was voluntary. Players pushed back and said athletic meetings, practices, and whatnot were always perceived to be mandatory. Players also testified that academics took a back seat to athletics. One athlete stated if it was between studying or going to practice, he would rather go to practice and then get his studying in the wee hours of the night. Would rather do that than miss a practice. Second round of hearings, which we just had last week, I believe they continued into this week, although I didn't see any reporting specifically about this week, but we will hit on what was talked about here this past week. There was testimony from the associate athletic director, Perrier, for University of South Carolina. He stated that the basketball team does not have rules, but rather team expectations.
Yeah.
Obviously, rules would imply some sort of control over these players, right? When asked if a player had to complete a form to seek outside employment, Perrier answered that he just didn't know. 3 other athletic department employees also took the stand, but they really didn't offer much information for the record. Obviously, they have been coached by their legal team into what they can say and things they really shouldn't say. I'll go back to that rules versus expectations. Clearly, that was something that the lawyers made sure they talked with this associate AD about in terms of how he's discussing and couching his comments. A few tidbits from these other 3 academic department employees, just some things that were brought up. They referred to punishment from coaches as accountability activities, and they attested to the usage of clipboard or clip cards for meals on road trips. In a statement that USC gave afterwards, they said that the testimony given was about the commitment, resources, and effort that USC provides to support student academics and athletic success, protect their health and safety, and help create a foundation for a future career in their desired field. NLRB continued to try and prove joint employment status by bringing up the move of USC to the Big Ten. They asked if the travel time here would have a negative impact on athletes and their academics. Their attorney stated, they being the NLRB's attorney stated, when you make a student athlete fly across the country, that speaks to the commercial nature or the business nature of college athletics. Moving forward, it is expected that there will be several months of deliberation after this round of hearings and testimony, several months of deliberation prior to an eventual ruling, a ruling that could continue to alter dramatically college sports as we know them today. Again, as I said in the beginning, really surprised we're not getting any other information from this. I found a few articles, just a few articles, local reporting on this. This is a national, massive issue. So I'm blown away that we can't find much. I'm happy. Hopefully, if people haven't been reading that, hopefully they're hearing about this for the first time. And I would like to stay on this because, yes, USC is going to be a Big Ten member. Obviously, we've been following the collapse of the Pac-12, and we are getting into the future of the NCAA in football. So it kind of hits the trifecta for us here, Steve. So I'm going to stay on this to see if there's any new reporting. This is what I could find for now. I want to shoot it to you for your opinions on this.
Yeah, so for me, this case kind of runs parallel to a lot of the antitrust federal cases we've been seeing over the years. The most recent example, we've talked about it a few different times. There was a case where there was some kind of compensation was being restricted by the NCAA. I think it was either medical compensation or class or education-related compensation. Mm-hmm. And that was just one case in a long string of cases where the Supreme Court ruled 9-0 against the NCAA for basically saying that the ruling was about compensation and trying to restrict compensation, but within the regular opinions that were written, the majority opinion and then the concurrent opinion, they talked a lot about how the NCAA, however long ago, back in the 60s or whatever, created this imaginary thing that was all of their imagination of this student athlete.
Right.
which does not exist in U.S. law. You are, if you do something and you give labor towards something that produces money, that produces revenue in some way, and you are compensated for that, you're not in this an imaginary unicorn student athlete. You are basically an employee. You're doing something. So whether you're getting a scholarship, which has value,
Right.
or you're getting free meals, whether you're getting gifts, or whether you're getting paid cash money, you are basically exchanging your labor for something. So you need to basically you're an employee of somebody. Okay.
And student athlete, if I can interrupt real quick, student athlete, very similar to the amateur status of what we're talking about with the Olympics, right? So a little bit interchangeable. Call it a student athlete, call it amateur status,
right?
Same type of deal. But.
Right, and yes, you're exactly right. And they talked about amateurism,
right?
And basically how again this was nothing that was really supported by law at all, and actually goes against the U.S. law. We talked about antitrust laws before. And in this case, this is labor laws.
Law.
So this doesn't surprise me at all. It's there's been a couple cases before where players tried to unionize. I think Northwestern maybe about 10 years ago or so. Now in this case, I think, and you can correct me if I'm wrong, I think it's just 2 players that are doing this.
Yeah, that's a good question. There was 2 that gave testimony.
Okay, all right.
I'm not sure how many technically are named within the NLRB, but it's the NLRB that's taking the case to USC. So
right.
the number of players is somewhat irrelevant,
right.
but I saw specifically 2 players gave testimony.
Well, I think there's a big sentiment out there of, if the players want this, they want that. Well, in some cases, it's not really. Some of the players are very happy with the situation as it is because they're getting what they want. They're getting a free education. They're getting like stipends and different things.
Sure.
They're getting a shot at the NFL. But in this case, it's the NLRB saying that USC and the NCAA, the PAC, are acting inappropriately, that they are breaking labor laws. So I think it's important not to just, for people who don't love this whole situation, don't just focus on the players because a lot of the players are happy with their current circumstances. Yeah. So, the NCAA, they created this. It was their own thing, the amateur student athletes, that it's not supported by U.S. law. Now, one of the parts you talked about, this becoming a business.
Yeah.
And a good example of that, there's been many examples over the years. It's been becoming more clear every year that big-time college sports, whether we're talking about college football or March Madness, college basketball that earns, hundreds of millions of dollars as well, this has become a business. And we did a lot of breakdown. Why did USC, UCLA, Washington, Oregon go to the Big Ten? Because they could make more money. It's more revenue. That's what it is. That's when you're making decisions for money, that means it's a business decision. So what are you? You're a business.
Sure.
And so now players are, and under the current structure, it's not just football players and basketball players. It could be lacrosse players, soccer players, whatever, are having to travel cross country. So they're giving even more time commitment to these sports. They're and they're still providing labor. They're in all intents and purposes, I think if the NCAA never created this thing that we've kind of been brainwashed on, everybody would just say, "Oh yeah, they're employees. It is what it is." So pay them a wage, do this, do that. They're employees. And you have cases in, I'll call real life, where like my daughter's a college student and she has an on-campus job.
Sure, right.
So she goes to school and she's an employee of the school district, or of the college, and she gets paid for the hours that she works. Now they have limits and they have restrictions. She has to, I think, have a certain GPA, and she can work so many hours. So it's not like this is unprecedented. All colleges and universities employ. It's just unprecedented for the NCAA because we have this system that's lasted so long. So I think they make a lot of good points in there, and they back it up. And honestly, schools like USC, UCLA, whatever, they're kind of bringing this upon themselves because they're backing up that evidence that they're making these decisions based on business decisions because they're moving conferences, they're adding more money. We've done so many episodes about realignment, conference expansion, and these are all money decisions. We see the hundreds of millions of dollars that the conferences and the schools are bringing in TV rights, so it's very apparent this is a business. Now, what's going to be the final decision? I have a feeling that it just seems with all the evidence that they're going to be ruled employees. So how is that going to affect Everything. Well, there might be at USC, the athletes there, the student athletes, may decide they want to unionize, and that may happen there. Whereas if you look at SEC schools and programs, maybe in Georgia and Alabama and other places, maybe they don't want to unionize and all that. But if they are ruled to be, at the federal level, ruled to be employees, then there's going to have to be some changes to how the PAC, all the conferences and the NCAA treat their employees, and it's going to make for a whole lot of changes.
Well, two things I want to add, and the first is this unionization thing, because I've been listening and reading some of these things where they're going, everybody has to unionize, they're all going to be in union, and I'm saying, they don't have to be in.
No, absolutely.
They don't have to be.
Right.
They can be. That's one solution.
Yeah.
But they don't have to be in.
Correct.
A union. So I think that's really important that people understand. It's not all or nothing.
Right.
It's an option. The other thing, and I agree with you, I think at least where we're at right now and the little bit of reporting that we're getting and the understanding that I have, I would say it's leaning towards that they're going to be found to be employees. I would agree with you on that. I do want to push back a little bit on one thing, not to make this an overly long episode, but when you get into their choice, and that you heard that a little bit, and I'm not saying this is enough of a reason for them to not be an employee, but in terms of the one player saying, I'd rather go to practice and study in the wee hours of the morning. Now, is that forced upon him or not? I don't know. I mean, I think we can all kind of determine what that means. If you want to start. If you want to be a starter, if you want to get playing time, you better be at freaking practice. Right. I get that. But you're making a choice to put your athletics above, at that given hour of the day, your academics. And you're also making a choice to go to USC to play. I mean, we're talking about football players, to play football. Because if your goal is, and the vast majority it isn't, but if your goal is, I want to go to a university to get exposure, to get to the whatever it is, NFL, and there's other leagues as well, that's your choice to do it that way. There's other ways to do it.
Right.
You don't have to go to a college. Now, people are going to be like, yeah, you do. You got to go to a college to get exposure. But you don't have to do that. There's other options for you. There's other avenues for you. It gets back to a little bit of our discussion on the NCAA thing, where I'm like, well, if you want a junior NFL, make a junior NFL. And maybe that's part of the problem. There really isn't a great alternative to the college experience. And so maybe I'm answering my question. I guess I'm just saying, when you hear this, I'd rather study wee hours of the morning. Hey, we all make our own choices here,
sure.
Right? You're a student athlete. You have a choice to make whether you want to do it or you don't. So maybe that's a little bit of the pushback. Again, I don't think it's enough to say they're not going to be employees, but they're choosing this route.
Yeah, I think that this article, there's just been so little reporting.
Yes.
They really focused on that, and that was part of the arguments. And I think that they were basically, the NLRB was going, their lawyers were going for that because the school is saying, oh, this is a voluntary activity.
Correct.
It's not like a club. If I'm in, and yes, we all make choices. We make choices with our employers. Like,
correct.
I could choose not to go to work tomorrow, and my employer could choose to fire me.
You.
Yes. But I think what they were trying to show is this isn't just like a voluntary club like the Glee Club or Lions Club or whatever. That this is basically how the relationship works is they have to do something in order to get their something in return that they want. But definitely good points. And I don't think that the whole choice argument is the best argument for them as far as showing they are employees.
Sure, right.
I think some of the other things more just showing you provide labor and you get compensation for that labor. It's pretty cut and dry.
Sure.
Now, I have seen some I have seen some people say even if they are ruled employees that even if this case could rule that that the USC athletes, because of this the structure that is set up, could be ruled employees. However, other schools or conferences who have other rules or structures, it could be where they're independent contractors, where they can get paid, they can get compensation, but they don't necessarily work for that school. So that could be something we could look at in the future.
Yeah.
And a good example of that, referees.
Yeah. Sure.
We're in Pennsylvania at the high school level. Referees get paid to do games, and they get paid by the school districts. However, they are independent contractors. They are not direct employees. So That's another kind of scenario that I've seen thrown out there, that they'd be 1099s instead of direct employees. Yeah, I think that's pretty much everything I had to say.
And I think it gets back to your point of where the NLRB is trying to go. I struggle to say that, NLRB.
Yeah.
You know, is it rules or is it expectations? Is it control or is it accountability activities, right? Like, it's about how much control do you have over these individuals. And that's what it's going to come down to. Clearly, there's a lot of expectations or control over these individuals for a lot of good reasons. Like, they want to have a great program. They want to be a national champion. There's certain things you have to do in order to be a national champion. And that's where the rub, I guess, becomes.
Yeah,
right?
and I think if the schools if they really push and try and make that argument of, oh, they're just normal school students, they just come here as like like my daughter's in the T club.
Sure, right.
Well, if she doesn't show up to the T club, like, there's not going to be any repercussions.
Yeah.
Where this is obviously a little different. So I do think it's a little false on their part. To try and make that claim, but I guess that's really what they have going for them.
Yeah, it might be all they got, right? So, hey, I am going to, as I said, I'm going to put that episode up on the end here, the end screen for the NCAA and where we think they're going to be in 2030. Obviously, a lot is going on right now. We do have a series going to be out. That NCAA was the first episode in a series that we're doing in College Football 2030. The other thing I want to mention, we have had numerous comments about the FSU amendment. Yeah. And if we're doing an episode on that, yes, we're going to do an episode on the FSU amendment. Look for that to come out on Monday. For those that have been on this channel for a while, you know we like to digest things, think about things, and then give them to you more from an analysis perspective and some opinions that we have. That doesn't happen overnight. We also are two guys that have families and jobs. Yeah. So we try to get you guys what we can when we can. But look for that episode on Monday. We'll continue on all this good stuff. I mean, I'm enjoying watching this. Just so much going on right now. And we'll stay on as much as we can. With that, we appreciate you guys for watching. We'll see you next time on the Big Mountain.